Balake. Where is Balake at?
My name's Blake.
Do you want to go to war, Balake? I'm for real. Ron.
Oh my God, what happened? Zach, where are you? Zach, did you freeze at the beginning of the video? Oh my goodness. Oh, wow. This is going to throw me off big time. What am I going to do, guys? I need Zach for the video, and Zach is frozen. Zach, if you can see me, try removing yourself completely and then bringing yourself back. Wow. This is embarrassing. Let me see. Let me figure out what I can talk about. Okay, guys, here's the news. There's like 6 different lawsuits pending against Scientology and David Miscavige. One of those lawsuits is a suit that was brought by the Jane Does in the Danny Masterson case. The Jane Does, Jane Doe 3's husband. I run the risk of misstating the additional parties who have been added, but the Jane Does plus a couple spouses and another woman, Patricia Vesey, has just been added. Trish Vesey testified in Dana Masterson's first trial. She did not testify in the second trial. Dana Masterson was not charged with the crime against Trish Vesey, but she testified as a past bad acts witness. Her testimony was the crime committed against her by Danny was equally horrible as the crimes Danny was actually charged with. Now, so this lawsuit brought by these Jane Does was for the stalking, intimidation, harassment, and fair game that they had been subjected to since coming forward. And that lawsuit was against David Miscavige and Danny Masterson and the Church of Scientology International. That lawsuit, there has now been an amended complaint filed, and they have added RICO, civil RICO charges to the complaint. And to my understanding, Jane Doe 2 and Jane Doe 3, you guys can fact check me on this, have also added, remember, you can sue for, Danny can be sued civilly for the crimes he has been convicted of criminally. And Jane Doe 2 and Jane Doe 3, to my understanding, have added those complaints to this lawsuit. Now, what's interesting, and this is going to be part of the some of the questions that I ask Zach about, if he's able to rejoin us, Zenu willing. Oh, it looks like Zach is back. Zach is back. Hello, good sir.
So sorry about that. Welcome, everybody. My apologies. Just as we went live, I dropped my internet connection.
Okay, so your sound sounds pretty good. For anyone, any newcomers, you can find Zach's YouTube channel at Your Lawyer Friend Zach. If you're not subscribed to him yet, you definitely want to get over there and check that out. Okay, so what I've done, I haven't shown the new filing yet, but I've been describing what the new filing is. I described the civil RICO. I also described Jane Doe 2 and 3 adding complaints for the crime Danny was convicted of. And one thing I was about to explain is that the civil RICO charges that have been added have not been added for Jane Doe 1. In other words, just help me with the language on this. So Jane Doe 1, the complaint has been amended, but these new, I want to say accusations, I want to say charges. What is the right word? The new complaints?
Yeah, the new allegations set forth in the complaint. But yeah, all the allegations of what they're alleging was done to them illegally.
Okay, those new items that are being added, for whatever it's worth, have not been added for Jane Doe 1. It's for all the others. And that's an interesting thing that I want to ask you about. So let me just get right to, there we go. Here's the new filing, guys. Second amended. Oh, it's the second amended complaint 4. And we see these additional items that have been added. Violation of the Racketeer Influenced and Corrupt Organization Act. Violation of the Racketeer Influence. What is that, just a duplicate?
No, because each one of those is going to correspond to one of the particular plaintiffs. So RICO
I got it.
allegation 1 corresponds to one Jane Doe. RICO allegation 2 corresponds to a different. So each person, there's multiple plaintiffs. Each plaintiff, if there are, let's say there's 5 plaintiffs and they're all alleging something, there should be a minimum of 5 allegations. So each one
Got
of
it.
those RICO complaints is going to do one of two things. It's either going to go to a different Jane Doe, or it's going to come from a different set of common facts. But I assume in this case, it's going to a different Jane Doe.
Okay, good. And it's also been explained to me that technically this filing is a request to the court to allow these additional items to be added. It's actually not a given that the court or the judge is going to approve it, but that's something else that I'll ask you about momentarily. Let's jump down to some of the introduction items here. I just want to read for the viewers because they just crack me up. The defendants are members of a criminal enterprise within Scientology. That criminal enterprise includes many individuals, including the individual defendants, and a number of corporate entities, including the corporate defendants. 2, defendant David Miscavige is the undisputed and unquestioned leader of this criminal enterprise and derives significant financial benefit from Scientology's criminal and unlawful activity. 3, Scientology was devised by L. Ron Hubbard, a science fiction author who was dissatisfied with the income that vocation provided him. As his wife explained, Hubbard believed that the only way to make any real money was to have a religion. That's essentially what Hubbard was trying to do, get a religion where he could have an income and the government wouldn't take it away from him in the form of taxes. Wow, it says that that's what his wife said. Okay. That's news to me, but okay. A science fiction associate of Hubbard's similarly recounted that Hubbard believed the only way to make $1 million was to form your own religion. 4, Scientology's self-described governing philosophy is make money, make more money, make other people produce so as to make more money. That's a direct quote from L. Ron Hubbard. I can testify to that. Many of Scientology's criminal enterprises' money-making schemes are criminal in nature. It routinely and systematically engages in fraud, human trafficking, identity theft, and money laundering to fill its coffers and enrich its leadership. Amazing. 6, Scientology's criminal enterprise also makes money by selling pseudoscientific auditing sessions. Scientology's criminal enterprise claims these sessions bring people from a condition of spiritual blindness to spiritual existence, and that they cure arthritis, dermatitis, asthma, coronary difficulties, eye trouble, bursitis, ulcers, sinusitis, cancer, and any number of other physical ailments. As benefits such loftily purported results, customers who purchase the entire course of auditing sessions spend upwards of $500,000. Okay. 7, as with many criminal enterprises, Scientology takes steps to protect itself and its co-conspirators from governmental authorities. Scientology's criminal enterprise takes a two-faced approach to protecting its criminal activities. It simultaneously presents an innocuous front to the public while terrorizing any who speak out about its unlawful activity in order to intimidate them and dissuade them from seeking protection from law enforcement or from cooperating with governmental authorities. Okay, interesting. Let's keep reading a little bit more here. 8, in order to provide itself with a patina of legitimacy, Scientology's criminal enterprise recruits celebrities to serve as its public ambassadors. Defendant Daniel Masterson is one such celebrity. During Masterson's long association with Scientology, Scientology's criminal enterprise used its resources to assist Masterson with his burgeoning acting career and provided him preferential treatment within Scientology. In exchange, Masterson publicly supported Scientology and its criminal enterprise by, for example, claiming that Scientology cures depression. Okay, I don't necessarily want to read all of these, but here's one. Scientology's criminal enterprise's harassment campaigns are carried out by Scientologists within that enterprise, but Scientology's criminal enterprise also uses its significant resources, including the proceeds of its criminal endeavors, to hire outside agents, that is non-Scientologists, to implement and carry out its harassment campaigns. Prior to the events alleged herein, Scientology had known for years that defendant Danny Masterson had raped and sexually assaulted multiple women. In order to protect defendant Danny Masterson and to protect itself, Scientology's criminal enterprise chose to bury knowledge of defendant Danny Masterson's crimes. Okay, it goes on to provide some details. Okay, very interesting stuff. So I have some questions for you. Let's see here.
Let's do it.
Okay, so let's say that the judge approves. Well, maybe that's the first place to begin. The idea that the judge actually has to approve the request to add these additional charges. What are your thoughts on the likelihood of that happening?
It's so the way that it was styled, the way it said on the top, it doesn't appear to be a motion to amend or leave application for leave to amend. They've styled it just as a second amended or third amended complaint. Most jurisdictions allow you to amend once as a matter of due course. Some allow you to amend multiple times. So in any event, whether it's automatically amended and accepted as a matter of due course, or they've exceeded the number of automatic amendments and they're asking for permission, either way, I don't want to say it's rubber stamp. The judge will take it into consideration, but I have full belief that any amendments they're seeking will be approved by the judge, because the parties have the right to lay all of the allegations and defenses, not just a right, an obligation to lay all the rights, all the allegations and defenses on the table from the beginning, so everybody knows what needs to be discovered and what needs to be tried at trial.
Okay, interesting. Is it correct? Am I correct? My understanding is that one of the benefits of adding RICO to the complaint is that there's an element of if Scientology loses, they're responsible for the legal costs. Is this actually a factor? Is this sometimes a strategic factor in lawsuits?
There are a couple of things going on here. One, there is this concept in the law that says if I've been wronged by somebody, I have one opportunity to sue them for that wrong. So if I allege that they've done 10 things wrong, I can't sue them 10 times for one issue at a time. I have to put all my issues on the table, and I win some, I lose some, whatever, but then I'm done. I can't lose one and then come back and sue on another one and then come back and sue on another one. I get one, because it's, if everybody who has 10 allegations files 10 lawsuits, the courts would just be drowning in paperwork. We'd never get anything done. Um, and so that's sort of part one. Part two to that is RICO. In this case, it's a civil filing for RICO, which is the Racketeer Influenced to Corrupt Organizations Act. There is the civil component to RICO in most states, including California, it appears, has what's called a cost shifting provision. Normally, if I sue you because you rear-ended me in a parking lot and I win, I have to pay my attorneys out of whatever money I get. That's called the American rule. Everybody bears their own cost. But there are certain things the courts and the legislatures have said, it is so egregious and so bad what you did. Not only do you have to pay your attorneys, you have to pay yours as well. And so
I fear you might have frozen again, Zach.
I can see me move. Did you hear
There you are.
the answer to the question?
There you are. You're back. Okay, there you're back.
Okay.
So
Okay, I'm here.
Before you cut off, it did sound like you were saying that you have the traditional concept of everyone carries the burden of their own cost of litigating, but in RICO, the idea is what you've done is so severe that if you're found guilty of it, you've got to pay the other's costs.
Exactly. Primarily because by definition, RICO involves more than one person. So if this group of people all acted together to harm one person, why should that one person have to foot all of the legal expenses necessary to take out 10 or 12 people?
Got it. Does the inclusion of civil RICO charges change the burden of proof that is required to prove the case?
No, the plaintiffs will still have to satisfy what's called the preponderance of the evidence rule, that more likely than not, if we put it on a scale, they just have to show by a little bit more that the defendants did it, as opposed to the criminal standard, which is beyond reasonable doubt. What RICO does is RICO adds a level or two of complexity. Now I don't just have to prove these individual elements. I also have to prove that all of these things tie together as part of this grand conspiracy to commit wrongdoing. And that can often be a lot more difficult. And this dates back to the days of, like, I could bust a dope dealer selling dime bags on the corner, and the kingpin is so far removed that I can never show that he had anything to do with that street dealer. But if I can tie all of the knots together to show that ultimately Uncle Pablo's pushing all this dope across the streets of America, I could go get him. That's actually what RICO was designed for, was to take out the kingpin drug dealers, not just the street level dealers selling nickel and dime bags.
Is there an element of having to prove not only the act, but the damages that does it introduce an element of that that wasn't already present in the lawsuit?
No, so every with the exception of defamation, really, and a few other torts that don't apply here, you always have to prove some sort of damage. There's always a damage element. Like if you were in my car, you misbehaved, but if you didn't damage my car, I'm not out any money. My car didn't go down in value. I don't have to pay the repair shop, and I didn't get injured. So there's always a damage component to it, but it can be a little bit tricky trying to prove that damage component in this grand conspiracy. But I think there's enough evidence so far that I don't think that's going to be an issue.
Now, my understanding is that the lawsuit as originally filed, the complaints were relevant to all of the complaint, the alleged. I'm struggling with the language here. What are we're calling the plaintiffs? We're calling the Jane Does the plaintiffs, right? Okay, that the complaints were relative to all the plaintiffs. With the addition of these new complaints, and that they're not relevant to all of the plaintiffs, is there a risk that the judge is going to separate the parties, separate the plaintiffs into two different actions?
No, so the term for that would be bifurcate. I can't imagine that would be the case because let's say, there's, I don't know, 50 or 60 allegations or whatever. Let's say there's 50 allegations and 40 of them, all the Jane Does, all the plaintiffs share in common. 10 of them, all but one Jane Doe share in common. The judge isn't going to try 10 just for this Jane Doe, or 50 for this Jane Doe, for the Jane Does, and 40 for this one Jane Doe. They're going to try them all together, but it just means that the Jane Doe who didn't plead a RICO violation, she just doesn't have to prove the RICO. The rest of them do, but they're still going to try it all together because we don't want to have to call the same witnesses 5 times. We don't want to have to call the same experts and pay them 5 times for 5 different reports at $15,000 a report. They'll absolutely try this all together, and the judge will be very clear with the jury. It'll be complex, but the judge will tell the jury, here's what Jane Does 1, 2, 3, and 4 have alleged, and here's what Jane Doe 5 has alleged, or however it breaks up. So the jury will be informed. These people have pled all of these things. This one has only pled this, but not RICO. So the judge will let the jury know what they need to be watching for.
Got it. Okay. And there's an element of this that I'm just personally confused about, which is adding to the complaint the items of the rapes. To me, I'm confused how, originally when the lawsuit was, because I know that I say I know, but I have to. So Jane Doe 1 and Jane Doe 2, Danny was found guilty of those crimes. My understanding is that Jane Doe 1 and Jane Doe 2 have 12 months from the date of the date he was convicted to file a civil suit against Danny for the rapes if they choose to.
Correct.
I'm confused as to how those complaints. And by the way, Jane Doe 1 has not filed that additional item for this lawsuit was not filed for Jane Doe 1. I don't understand how a complaint like that can be lumped into an existing suit that has to do with stalking and harassment. It seems like they would be separate suits. I just don't understand that.
Well, because ultimately it goes back to the same parties. The whole purpose is we want to adjudicate everything between these two groups of people. Every wrong that's ever been alleged, we want to adjudicate between these two groups of people. Some of those allegations are the crime for which Danny was convicted, which happened prior to the stalking harassment. And this other group of allegations are the stalking and the harassment and the RICO violation, or violations, plural. Every crime has a civil counterpart, right? So in the criminal world, we call it rape. And in the civil world, some states would call it, civil rape. But most of the time it's like, sexual battery. Battery is a tort. And then if you do it against a person in the manner Danny did it, we would just call that sexual battery or sexual assault. Those are torts. Absolutely. And so since it's the same group of people, same plaintiffs versus same defendants, we're just going to put all of our cards on the table and we're just going to fight like crazy people. And the last man or last woman or last women standing win. But we're gonna air all of our grievances, the Seinfeld reference. This is the airing of grievances. We're going to air them all right now and solve it all today.
Interesting. The issue that we've discussed on, I've been discussing on my channel a bunch, but I won't assume that all the viewers are familiar with this issue, where Danny has been found by the court to still be in violation of not only the terms of his bond previously, but the terms of his sentencing to relinquish all of his firearms. And we are very close to seeing search warrants issued for Danny's properties, his family's properties, and possibly even close friends' properties. The fact that it does look like there's been coordination between Danny, between some administrators in Scientology, and between Kate Mangles, Danny's attorney. Would any of this stuff be considered or at all, or used to help in this civil RICO issue, in your opinion?
I think it certainly could. And I think it's sort of a two-step analysis. The first is that evidence, the Mangles, the Jordan Masterson, the limited power of attorney, the dude from Tennessee and Oregon, that whole thing, that's absolutely discoverable. But just because something is discoverable doesn't mean it's admissible at trial. So it's a two-step analysis. But the first step is gather the information. And then once I have my hands on it as a lawyer, my job is to find a way to get it admissible at trial under the confines set forth by the rules of evidence. But I could absolutely make an argument that it's relevant. It is absolutely discoverable and at the very least arguably relevant. Especially even if it's not direct evidence towards something, it could lay the predicate, it could lay the foundation, or in the RICO case, set the predicate act. Like, these are the people who are working to conspire against these women. And one of the ways they do it is the weapon that's missing is the weapon that he used in the commission of one of those acts.
Interesting. Okay, last question I have. It's kind of a high level question. In your opinion, is there any way trying to add these charges to this suit at this time could have unintended negative consequences that I may not be thinking of?
Not that come to mind initially. Because here's the thing: you plead it, and that's the term. The term we use anytime somebody files a court plea or files a document with the court called a pleading. You plead these allegations, and then you go back later and you try to prove them. If you can't prove them, then if you can't find any evidence of it, it gets kicked on a summary judgment motion. And if there's a question of material fact, it goes to the jury. But if you don't ask, you can't win. The first step to win is you have to ask for the relief. If you can't prove it later, that's a different issue. But from my perspective, the worst case scenario is some of these allegations get dismissed. I mean, that's the worst that could happen, would be the allegations get dismissed. I can't formulate a theory in my mind, at least under the various theories of law I'm familiar with, where this could adversely affect any of the Jane Does at any point.
So, in this case, and this case has been going on for, I don't know, I want to say 5 or 6 years now, maybe 5 years, this suit. This is the one where Scientology was originally successful in their effort to get this lawsuit thrown into internal religious arbitration. And then on appeal, the Jane Does were successful in getting that decision thrown out. Does this second amended complaint being filed, does this open the door to Scientology being able to try and re-argue that it should be thrown into arbitration?
Not necessarily. I think the answer would technically be maybe, but I think from my perspective, the answer to that is no, because if the arbitration was not proper under prior allegations, if the arbitration agreement reads the same, and you and I know it absolutely is the exact same word, the exact same language, if it was improper, then it's still going to be improper now.
Okay. That was kind of my concern, whether somehow this opens some doors for Scientology that we don't want reopened. And so thank you for that answer. There's some other questions here, but I'm not sure. I have some questions that have been requested, and I'm not sure I truly understand them, so I'm not going to try to ask them. Let's take a look at some of the super chats here. Ben, the Dust Farter Turner. Good to see you, Ben. Thank you for joining us this evening. Yes, Ben, we're all very broken up about it. Thank you. Mary R, thank you very much. Mary R meant to say, could you put a link to the legal document in the notes? Yes, I will upload this to a Google Drive and put a link in the description. I'll also probably pin it in the comments down below. Julia O'Connell, thank you for making the documents easy to understand. Yes, thank you, Zach. It's It's awesome to be able to chat with you about these things. And Gary Mackey, retire Zach. Good evening to you both. Yes.
Good evening, Gary. I appreciate that.
That's a thing. Laura Waldy. Thank you, Zach and Aaron, for breaking this down for us. Great analysis. As always, Zach, hashtag retire Zach.
Thank you, Laura, for hanging out with us tonight.
Let's see. Let me hide that one. Okay. I feel like I'm going to have more questions on this. And if I do, let's revisit this issue tomorrow or the next day.
Yeah, absolutely.
You're around to do that? Okay.
Absolutely.
Good.
I'm always
Awesome,
around
guys.
for you. You know that.
And hold on. Let me one more time here. If you're not yet subscribed to Zach, find him over on YouTube at Your Lawyer Friend Zach. He can be my friend and your friend as well. All right,
I'm
guys.
a big
Thanks
dude.
for
There's
hanging out
lots
with
of
us
me to
this
go
evening.
around.
There's enough of Zach to go around. All right. Talk to you guys soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe